So, in Chapter 6, we will discuss the rescissible contract. Article 1380, contracts validly agreed upon may be rescinded in the cases established by law. So, the meaning of rescissible contract. Rescissible contracts are those validly agreed upon because all the essential elements exist and therefore legally effective. But in the case established by law, the remedy of rescission is granted in the interest of equity, or in the other word is one that was entered into legally by the contracting parties but has resulted in economic damage to one party or an outside party. The court can therefore rescind or set aside the contract for equitable reason. So next is binding force of rescissible contracts. They are valid and enforceable, although subject to rescission by the court when there is damage or prejudice to one of the parties or to a third person. In rescissible contract, there is no defect at all, but by reason of some external facts, its enforcement would cause injustice. So, next is the meaning of rescission is. Rescission is an equitable remedy granted by law to the contracting parties and sometimes even the third persons in order to secure reparation of damage caused them by a valid contract, by means of the restoration of things to their condition prior to the celebration of said contract. So, next is requisites of rescission. These are the following requisites in order that the remedy of rescission under the chapter may be availed of. So, we have 7. So, first, the contract must be validly agreed upon. Second is there must be lesion or pecuniary prejudice or damage to one of the parties or the third person. The third one is the rescission must be based upon a case especially provided by law. Article 1380, 1381, and 1382. The fourth one, there must be no other legal remedy to obtain reparation for the damage. Next is the party asking for rescission must be able to return what he is obliged to restore by reason of the contract. 6. The object of the contract must not legally be in the possession of third person who did not act in bad faith. And the last one, the period for filing the action for rescission must not have prescribed. So, next is the cases of rescissible contracts. The subsidiary action for rescission, Article 1383, is limited to the rescissible contract under 1381. So, meaning to say, ito yung mga cases ng, example cases ng rescissible contracts. So, first is contracts entered into in behalf of wards. A ward is a person under guardianship by reason of some incapacity. As a rule, the power of the guardian with respect to the property of the ward are limited to mere acts of administration. Contracts involving real property must be approved by the court. So otherwise, they are unenforceable. For example, G is the guardian of W or ward. G sell the property of W worth 20,000 for only 15,000 pesos. The contract sale cannot be rescinded because the lesion is not more than 1/4. However, if the property is sold for less than 15,000, W can rescind the sale by proper action in court upon reaching the age of majority. So, second is the contract agreed upon the presentation of absentees. An absentee is a person who disappears from his domicile, his whereabouts being unknown, and without leaving an agent to administer his property. A court may appoint a person to represent is specifying his power and obligation in accordance with the rules concerning guardians. So, It must be noted that the paragraphs 1 and 2 refer only to transaction by guardians and absentees representative. Rescission cannot take place if the contracts have been approved by the court. As general, lession does not have invalidate a contract except only in special cases specified by the law. See the article 32. Next is the contract undertaken in fraud of creditors. The action to rescind in fraud of creditor is known as action Pauliana. Here is in number 4, the remedy of rescission may be availed of by the third person, such as contracts are usually made without the knowledge of creditors, in order that the fraud of creditors may be valid ground for rescission. The following requisites must also present. The first is there must be an existing credit prior to the contract to be rescinded, although it is not yet due or demandable later. Then next is the subsequent contract made by the debtor conveys a patrimonial benefit to a third person. So next is there must be a fraud on the part of the debtor which may be presumed or proved. And last one, the creditor has no other legal remedy to satisfy his claim. That is, he cannot recover his credit in any other manner, it not being required that the debtor be insolvent. So, next is the contract which refer to things under litigation. In number 3, the purpose of the remedy is to secure the payment of an existing credit of a third person against the party to a contract sought to be rescinded. Here, the purpose is to make effective the claim of party litigant over a thing under litigation which was the object of a contract entered into by the other party with another person. The right to file the action for rescission arises in favor of the plaintiff when the defendant enters into a contract over the thing in litigation without the knowledge of or approval of the plaintiff or the court. So, here's the example of the number, I said in number 4. S sues B for the recovery of parcel of land. In this case, the land is thing under litigation. If during the pendency of the case, B sells the land to C without the approval of S or of the court, the sale is rescissible at the instance of S. In the cases he wins in his suit for the recovery of said land unless C is in legal possession of the land in good faith. S, however, may protect his right by filing a notice of lease pendants. So, if the action involves personal property, S may petition the court of the issuance of an order of attachment or the appointment of a receiver to place the property. So, next is the violation of right of first refusal. The Supreme Court in a number of cases upheld the rescission of a deed of sale which violated a right of first refusal granted to one of the parties. The prevailing doctrine is that a right of first refusal means identity of terms and condition to be offered to the lessee and all the prospective buyers, and the contract of sale entered into a violation of the right is rescissible under Article 1380 to 1381. Such violation constitutes a valid cause of a action, enforceable by an action for a specific performance. Where there is no showing of bad faith in the part of the vendee, the sale may not be rescinded. The remedy of the person with the right of first refusal is an action for damages against the vendor. So, next is the rescission for breach of contract and rescission by reason of lesion distinguished. First, the rescission on account of breach of stipulation is not predicated on injury to economic interest of the party plaintiff, but on the breach of faith by the defendant that violates the reciprocity between the parties. It is not subsidiary action, that is, the action of rescission is not subordinate to anything other than the culpable breach of his obligation by the defendant. The rescission is a principal action, retaliatory in character, it being adjust that a party be held bound to fulfill his promises when the other violate his. Hence, the reparation of damage for the breach is purely secondary. Then, the second one, on the contrary, in the rescission by the reason of lesion or economic prejudice, the cause of action is subordinated to the existence of the prejudice because it is reason dietary as well as the measure of the right to rescind. Hence, where the defendant makes good and damage cause, the action cannot be maintained or continues as expressly provided in Article 1383 and 1384. But the operation of these two articles is limited to the cases rescission for lesion enumerated in Article 1381 and does not apply to cases under Article 1191.